Resurgent India Knowledge Series presents live webinar on navigating domestic arbitration challenges and winning strategies in infrastructure projects. Objective: to understand how current dispute resolution mechanisms fall short in addressing the realities of project delays and to examine the challenges in infrastructure arbitration practice under domestic arbitration. Resurgent Legal. Resurgent Legal LLP is a full-service law firm led by experienced lawyers with a proven track record across industries. We deliver timely, practical legal and regulatory solutions with a strong focus on integrity, clarity, and accountability. Our client-first approach ensures responsive service and long-term partnerships built on trust and professionalism. Practice area: corporate and commercial, employment and labor laws, mergers and amalgamations, insolvency and bankruptcy, arbitration and litigation services, startup assistance, foreign investment and exchange, litigation and dispute resolution, banking and finance, real estate and construction, insurance, infrastructure. Moderator: Mr. Sudhir Chandi, Director, Resurgent India Limited. Eminent speakers: Mr. Nagendra Nath Sinha, former IAS, Government of India. Mr. Santosh Paul, Senior Advocate, Supreme Court of India. Dr. Swati Jindal, Advocate on Record, Supreme Court of India. Mr. Sanjay Kumar Chhetri, Advocate, Resurgent Legal LLP.
Good afternoon, everyone. Let me just set the objective first. Today we have gathered here for webinar on alternate dispute resolution mechanism. So we'll be examining the shortcomings of the existing dispute resolution mechanism in effectively addressing project delays and to identify the challenges specific to the infrastructure arbitration in domestic space. Just to give an introduction, I am Sudhir Chandi. I am your host and I am Director with Resurgent India Limited. And I have with me distinguished panelist, Mr. Nagendra Nath Sinha. He is a retired government official and IAS. He is a distinguished officer of the 87 Jharkhand cadre, served as Secretary to Government of India in Ministry of Rural Development and Steel. He holds a bachelor's degree in electrical engineering from Indian Institute of Technology, Kanpur, and a master's degree in health science from Johns Hopkins University. Throughout his illustrious career, Shri Sinha held pivotal roles in both central and state governments, including Secretary Board and Management in the Ministry of Home Affairs, Chairman of National Highways Authority of India, and Managing Director of National Highways and Infrastructure Development Corporation Limited. He has spearheaded significant infrastructure projects such as Mega Sports Complex and Games Village in Ranchi, and Ranchi Ring Road, Ajwal Tapong Road, and Delhi Mumbai Expressway. His contributions to the policy development include the formulation of PWD Code 2012 and public-private partnership frameworks. As Secretary of Ministry of Steel, he championed sustainable growth and technological innovation in the steel sector. Shri Sinha's professional interests encompass sustainable development, information and communication technology, infrastructure, health and institutional building. I welcome you, sir, to the webinar. Then we have Mr. Santosh Paul, Senior Advocate, Supreme Court of India. Mr. Paul is a distinguished advocate with 37 years of experience. Since his enrollment in September 1988, he holds a BA in Economics from Elphinstone College, Mumbai, and an LLB from Government Law College, Mumbai. He secured the second rank in the college, an advocate on record examination. He began his career as a junior to Mr. C.V. Francis and has since maintained an independent practice, appearing before Supreme Court, Delhi High Court, various tribunals, while conducting arbitrations before retired Supreme Court justices like Justice A.S. Anand, specializing in judicial independence, insurance law, and constitutional issues. He has authored various influential books, including Choosing Hammurabi, Appointing Our Judges, and the Maoist Movement in India. With Choosing Hammurabi, this book is prescribed at various universities like Nalsar. His articles such as Lasky and the Collegium System, published in Economic Times in 2015, reflects his expertise in judicial appointments. His notable Supreme Court cases include Supreme Court Advocate on Record Association versus Union Bank of India. His pro bono book includes contributions to the 2013 Manual Scavenging Act, pollution litigation, and amicus curiae roles in consumer disputes. He advocates for Indian Constitution chairs globally, lectures at SDM College, Law College, Bangalore, and represent clients like Government of Maharashtra, Tata Motors, and Novartis India. I welcome you, sir, on the webinar. Then we have Mr. Sanjay Chetri. Mr. Sanjay Chetri is a seasoned legal professional with comprehensive expertise in arbitration and legal process across wide array of judicial forums, including civil courts, criminal courts, consumer courts, high courts, Supreme Court of India, NGT, NCLT, NCLAT, NCR, DRC, and various other arbitration tribunals. Presently, he is associated with Resurgent Legal LLP, and previously he has served as a senior associate at George Thomas and Company and Singhania and Partners LLP, and also as a partner with Francis and Company. As a distinguished member of Delhi High Court Bar Association and Supreme Court Bar Association, Mr. Chetri specializes in arbitration and litigation, with a focus on complex matters involving NHAI, railway contracts, FIDIC, EPC, BOT, BOOT, HAM contracts. Renowned for his strategic acumen, he has successfully represented clients in high-stake cases, securing favorable outcomes in significant arbitration appointment and disputes involving substantial financial stakes before premier judicial and arbitral bodies. I welcome you, Mr. Sanjay, on the webinar. Then we have Dr. Swati Jindal, advocate on record, Supreme Court. Dr. Swati is an esteemed advocate on record, practicing before Supreme Court of India, Delhi High Court, and various district courts and tribunals in Delhi. Holding a doctorate in criminal law, she serves as a legal member in the International Complaints Committee of numerous private and government organizations and is an empaneled advocate for various government institutions. Dr. Jindal has been a visiting lecturer at Law Faculty Center 1 in University of Delhi and is a prolific writer contributing articles on legal issues to the reputed journals and magazines. She has authored books on legal matters with a particular focus on women-related issues like sexual harassment of women on workplace and a chapter in engendering women in India and works on sexual harassment of women at workplace. Passionate about her women empowerment, she champions confidence building and leadership development, firmly believing in transformative power of women, supporting and uplifting one another for holistic progress. So, welcome all guests. So now with the introduction, we can now start question answer session. So we'll have this Q&A session and we'll stop at 4:55, and then for the last 5 or 10 minutes, we can take questions from the participants. And whosoever have any question, they can write in the chat box. We'll take it at the end of the seminar. So my first question to Mr. Santosh Paul, sir, according to you, what are the key challenges involved in the arbitration of the infrastructure projects? Sir, you are on mute, sir.
Yeah. As far as infrastructure projects is concerned, your challenges are threefold. One is the drafting of the contract stage. That it's a complex contract, and the biggest challenge is the drafting of the contract. The second is the situation of a dispute resolution, where you have a mediation and probably a mediation plus arbitration. That's the second challenge. And the third challenge is the actual, the process of what do you call the arbitration process, which culminates in an award. And thereafter, there is a challenge to the award. All these are challenges for an infrastructure project. And each area will require a great degree of expertise given the technical complexity of these infrastructure projects. So each stage is a challenge, and each stage will have to be dealt with the people with the requisite expertise in each of these fields here.
Thank you so much, sir. Sir, what sort of impact do legislative changes like, such as the rollout of GST, they have on the arbitration of infrastructure related disputes?
See, this is this, if it is factored in, it is not a difficult thing to deal with. But if this has come in all of a sudden, like the imposition of the GST, then it becomes a challenge. The second challenge is if there are variables of GST, then again it affects infrastructure costs. It affects also thereby the financing of the project. It also has the other problem of actually implementation. All this will go hand in hand if there are too many variables, like these kind of legislations which come into play. So it is difficult for parties to predict, but it is something which will have to be borne in mind when you draft the contract, that there will be variables during the execution of these contracts.
Right, sir. Sir, what are the most common issues in enforcing arbitration awards?
See, arbitration award, first is, I'll tell you what, that we have the situation of, the commencement of the arbitration process. Once the arbitration process is set in motion, you have to get the people of the requisite knowledge, especially in infrastructure projects. This is where I think most of the people, the contracting parties, are at a little bit of a what do you call, discomfort, because a question crops up: do legal minds understand the complexities of an infrastructure project? I myself remember having done the T3 arbitration. It was a serious challenge in trying to make the judges understand the key infrastructure issues which arose in that particular arbitration. Ultimately, I'll just give you a small illustration. You have, if you see the T3, you will find at several places welding is done, if you pay your attention as usual. That was not to be, because Delhi has a temperature which varies from 1 degree to 45 degrees centigrade. So what is required is actually these joints had to be what you call joined by pins with a lot of play in it. But the contracting party could not, the subcontracting party could not effect it, by virtue of which these weldings took place. Now, it became very difficult to make the judges understand the difficulty in this. This is not a substitute for the nut and bolts of that particular structure. Ultimately, it was presented in a audio-visual format to make them understand that the contraction and expansion of metal and how it will affect their entire structure. Only then they could understand. So this is one big challenge. That is how to make a judicial mind understand what is technically an engineering problem. Do we need judges plus engineers? That is something which at the contracting stage you should consider. Second is implementation, as you said, the award gets passed, then how do you implement it? That is a Section 34 challenge. The courts are burdened. I find it is, the boards of, be it whichever high court, whether it's Bombay High Court or the Delhi High Court, the volume of business is so large that they will not be able to deal with it and decide and adjudicate it within a very short time frame. It will take time. Now that's the other serious challenge, which by virtue of the amendments to the Arbitration Act, they have narrowed the scope of challenge. But still, the number of arbitrations which exist, the number of challenges, because each and every arbitration award actually gets challenged in the courts. I don't think there must be a very small percentage which go past the unchallenged.
Yeah, that's
so, enforcement is a problem because after the 34, then after you, so let's say the party succeeds in the 34, I mean the person who won the award, how do you implement it? I'm actually a matter. A consent award was passed by an arbitrator in Bombay, and it's 10 years since the execution is commenced. 10 years. And where is it stuck? The territorial jurisdiction of the executing court is challenged. So, the challenges are bizarre. The challenges are strange. What is we think is, defined wisdom in the legal fraternity, even that becomes a subject matter of challenge, and it takes a lot of time. So it's not an easy task. At every stage, as I said, is a challenge in an infrastructure project.
Yeah, that's a very practical thing and a very interesting example you gave. Sir, in what ways do current dispute resolution mechanism fall short in addressing the realities of project delays?
See, I'll tell you, this has always come to my mind because when I see these infrastructure projects, there is an there is a drafting of the contract stage. The parties enter into a contract. Thereafter, the contract is executed. There are disputes which run through and through and through. So, if there is a mechanism provided in the contract that certain disputes can be actually resolved, by a impartial body during the execution of the contract itself, you may be able to narrow down the differences, and you may not need to enter the arbitration stage at a, what do you call, when you reach the arbitration stage, you find an infrastructure project, those disputes involve 100 items, delay, quality issues. Quality issues, there are not less than 50 issues in each of those certain criteria, like for instance, the qualitative issue. So probably these can be narrowed down if there is some kind of an in-house mechanism provided in the contract itself. For during the execution of the contract itself, you try to resolve it.
Yes, sir. So one last question from you. I know you have to leave little bit early, so I'm just asking you all the questions directly from you.
Yeah.
In your view, can you throw some light on the recent judgment of the Supreme Court holding that courts can modify arbitral awards in certain circumstances?
See, I'm in full agreement with what the Supreme Court did. Firstly, it did not open up an arbitration award for modification in all situations. It is only a very narrow sphere, interest element, and certain other spheres where they have a limited role of modification of the award, which is very right, because for a small issue like interest, if you set aside the award, like I've seen these infrastructure projects, sometimes the arbitration runs into a few years. If you're going to set it aside and you're going to set it back to a new set of arbitrators, it is an extremely difficult, cumbersome process because it will be counterproductive. The whole purpose of arbitration itself will be counterproductive. So what they have done is on a very limited sphere, they have allowed this opening up. Otherwise, if there were a lot of advocates who said, you should have opened up and you should be able to modify it, but then it will become a hearing like a first appeal. like you hear in civil disputes. So every fact will be a subject matter of challenge, which is not what the Supreme Court has done. It's a very narrow compass. And then what the Supreme Court has done is a very pragmatic view, and in my opinion, a correct view of the matter.
Thank you so much, sir, for throwing light on these topics. Now I'll move towards Mr. Nagendra Nathji.
Thank you so much. Yeah.
Yeah. Thank you, sir, for joining. I know you have some other engagement. Thanks for sparing time for us. Sir, Mr. Nagendra Nathji, sir, what unique challenges arise in arbitration when government is the contracting party in the infrastructure projects? I think, yeah, from your experience in NHAI and NHIDCL would really help us, sir. Sir, you are on mute, sir.
Can you hear me now?
Yes, sir, we can hear you loud and clear, sir.
Okay. The issues when government is a contracting party are manifold. The first thing is that government does not like to take the arbitral decision and implement until unless it has exhausted all judicial remedies possible. The reason is this, that these decisions are subject to review by multiple authorities, and until unless all judicial avenues have been exhausted, people like to litigate. So many matters land up at the highest court, like Supreme Court, high courts, etc. And therefore, the arbitration, which was meant for easy and quick disposal of disputes, do not actually serve their purpose. The other issue is also this: government is a fair employer and has to extend the same treatment to all the contractors. So in a particular case, if the government were to take a particular view in respect of a particular contract, other contractors also demand and similar treatment, and therefore the implication does not remain limited to one particular contract, unlike the case where the government, the private parties are the contracting parties. So that brings another dimension to the complication. The third dimension is the issue of institutional memory and strong documentation. Generally, people are subject to transfer, like firms, etc., where there is a strong legal department and people are there for quite some time. Here, the institutional memory is limited to the officers who handle those particular matters. So therefore, because of the transferable nature of the jobs, there is a lot of lacuna and gap in the not only the prosecution of the arbitration, but also in terms of implementation as well. So, and in terms of documentation as well. The allied challenge again in this matter is the issue of documentation. Generally, the documentation is not as elaborate as and as well maintained as what is done where people have legal assistance available in terms of legal department and legal personnel to handle the legal, the arbitration related and the contract related matters. And therefore, there is a degree of asymmetry between the government and the non-government parties, and often this leads to an accusation of unfairness and arbitrators not acting fairly and impartially. And the last point which I would like to mention is the issue of the lack of expertise and lack of sensitization towards drafting communication and contracts in a manner in which the legal rights of the government parties are protected. So in that sense also there is a difficulty. I remember when I was the Steel Secretary, we were reviewing why the Steel Authority faces disputes and is unable to handle. At that point in time, arbitration was not the issue. But then, in terms of reform of the system, we assured that for each of the case, there is a repository of documents, and all contract-related documents go into that docket. There is legal assistance available for each particular contract, and if there is necessity, people consult the legal advisor or representative while drafting those communications. So these are some of the issues which come in the way of contracts when one party is a government or related party, for example, a PSU or a autonomous body or a subordinate body of the government.
Thank you, sir. I think it provides a lot of clarity on the question. Now I'll move towards Dr. Swati. So, ma'am, what are the challenges you experience in a petition challenging the arbitral award in the before the Supreme Court?
There are various challenges, Mr. Chandi. As you said that the speakers prior to me have also said that even though arbitration was, it was touted as an alternative dispute resolution in order to, do away with the problems that arise in a judicial system. One of the biggest problems that arbitration itself is riddled with is the fact that, with the advent of various amendments, now it has become extremely difficult to challenge an award per se because very, very limited grounds are available when you go ahead under Section 34 of the Act, 34(2) to be precise. Very limited grounds are available if you want to go ahead and challenge an arbitral award. It can either be challenged on procedural irregularities or on fraud or a very limited ground of public policy. So that makes it very difficult. And especially, when we talk about infrastructure projects, we know that on the one hand, we have a private entity, whereas on the other, we have the government infrastructure, which is in itself quite large. And they really have no limit as to the amount that they can expend in the legalities of the issue. They will keep going in, they'll spend thousands, lakhs, crores in the arbitration, and then they still have the capacity to go ahead and file an objection. And thereafter, various other things like senior advocate Paul said that, they would go in execution itself, which in itself takes years. On the other hand, arbitration itself, the Act says that there are strict timelines. Now they have under Section 23, so on and so forth, they have strict timelines of 6 months as far as filing of statement of claim and defense is concerned. Then they have, fixed up a further time period of 1 year subject to an extension of another 6 months. So all these time limits, again, they make it very difficult for a person, especially not very well versed with law, to stick within those timelines, because sometimes the timelines are not in your hands in order to pursue the process wisely. At the same time, the nature of the disputes are always such when we specifically talk in relation to the infrastructure projects, the special nature of the disputes is such that it is not easy to give evidence, or like this learned senior said before me, it is not easy for the judges to understand until unless an expert uh, uh, member is appointed as an arbitrator. It is not easy to make them understand as to why the delay, for example, was caused, if at all it was in fact a reasonable delay or not. Then the fact that, like I said, very limited grounds for challenge. On the one hand, we have minimum judicial review. On the other, the matter, once the award comes out, gets stuck in a vicious circle where, just in order to appoint an arbitrator, you go in a Section 11. Then there is also a discussion as to the validity of the agreement itself. Then the award comes out. Then there is another 34, then 37, then execution, so on and so forth. So on the one hand, I mean, it's such a dichotomy when we say that, it is a quick process. On the one hand, we are saying that judicial intervention is less, but at the, next instance, we are also saying that the judicial intervention is more. At the same time, there are enforcement hurdles. There is so much of cost and time that is involved. All these things, they contribute to various challenges when you actually go to enforce an award before the courts.
That's right, ma'am, and that's where people like you come into picture and help the client, right? Yeah. So, ma'am, can you suggest a strategy if there is any, to succeed in an arbitration proceeding?
Well, first of all, see, arbitration starts before it starts. That's what I like to say. So before an arbitration start, you have to draft such a perfect arbitral clause or an arbitration agreement that, in the future it can be of help to you. So drafting of that clear arbitration agreement coupled with a clear arbitration clause is the first step towards having a successful outcome in your case, in your dispute resolution. Then you have to prepare and enforce strict budgets. Being a party, especially a private party, you have to keep in mind, how much time it will take for every step of the dispute before it gets resolved. Keeping those budgets in mind, you have to apprise yourself of the cost and you have to act accordingly. Because if you go with an open budget, midway down the line, you will realize that you can no longer afford it. Then you have to select an expert counsel. Selecting a counsel who is good at litigation and selecting a counsel who's good at arbitration are two different ball games altogether. So we don't want a counsel who is so hard pressed in his own, court craft and the way he litigates before a court that he forgets what arbitration is all about and that it is all about strict time management. You also have to ensure now this problem comes with people who are, ad hoc into ad hoc arrangement and who are not into institutional arbitration. It becomes very difficult to select an arbitrator. So you have to draft your arbitral clause in such a way that you select the right arbitrator, and that is half the work done. If your dispute is topic specific, for example, if it deals with a specific area, it always pays. One of the, for example, arbitrations that I had was delays in construction. So the arbitrator, one of the arbitrators was himself an engineer, and he had been, into the thick of things for a long, long time. So it was kind of easy to make him understand as to, how it is that not building the basement first and then not laying the, concrete slabs first, how it led into a delay, how the project could not be finished on time and whose delay, whose fault it was. Then try your level best to settle the matter within the zone of arbitration so that you kind of bypass all the future impediments in the form of a 34 or an execution. So I would say that is the best legal way to sort of avoid any kind of disputes in the future, and you have a quick redressal at your, in your hands.
Yeah, I think very well said that arbitration starts even before the arbitration starts. I think that sets the that's a very good hint you have given to all the participants. Yeah. Now I move towards Mr. Sanjay Chetri. So, what are the services Resurgent Legal LLP is providing insofar as the arbitration practice is concerned?
Resurgent Legal LLP provides comprehensive arbitration and litigation services, which includes we help the clients in preparing content records during the period of the execution of the contract, or also drafting statement of claims or defending the client in such matters or preparing counterclaims. Also, we help the clients in securing interim papers, filing application for the court, Section 11. All the we have the package wherein we give you complete services under the Arbitration Council Act, starting from arbitration to litigation. We say we are there for arbitration. During challenge also we are there. 34 in 37 also we are there. In Supreme Court also we are there. We are giving A to G service under the Arbitration Council Act. That is our specialty. That apart, we are focusing on infrastructure practice itself. That distinguishes us compared to others. There are many counsel or many law firms in Pan India, which they does many things at the same time. Like rightly, Madam has said some time back, some lawyers may go to the court craft, but they're not dealing in arbitration in and out. So that is arbitration different ballgame at all. So in that way, we specialize in this arbitration practice only, and that is our domain practice.
Okay. So, Mr. Sanjay, according to you, what steps could client take prior to initiation of arbitration proceedings?
Prior to initiation of arbitration proceedings, clients should first of all review the contract. They should see the contract clauses. What is the contract clauses? And also in the contract, they have to see they have to comply with the pre-arbitration requirement, because many of the in arbitration clause you'll find that they have to go for DRB, for financial contract disposition board. The clauses are there. They have adhered. Without, you can't jump out the clauses. That many a time it seems that without adhering to the clauses, the client jumps to section 11, and it ultimately what will happen that it will take time, will complete the litigation, and the party will involve in waste their time, money in the litigations. So that we should avoid that. Also, uh, in arbitration clause, we will find the notice clause is there. So many a time we have to issue notice on a time. This certain deadline mentioned there in notice period. Because if you fail to if suppose you have a claim and you don't issue the notice for the particular claim, then your claim get timed. So despite having the claims, only because the clients are not aware of the fact that I have to adhere to the particular clause which is inside the contract, is the obligation of the parties. Also, they have to assess the claim, what they have to quantify the claims, explore settlement. All many of things are there. So basically, the client has to be thorough with their own team, saying that. So sometimes madam said that arbitration starts before it starts, meaning thereby the party has to make their own case by preparing continuous records. Record has to be there. Without record, you cannot initiate arbitration. Despite you claim, you will not have a substantiated. For quantifying the claims, you should have the records to establish how can you get those claims. So these are the factors which are paramount importance of arbitration.
Rightly said, rightly said. Nagendra sir, in your experience, what sort of challenges arise from the time gap between the contract award and the actual project commencement?
You see, can you hear me?
Yes, sir, we can hear you, sir.
I'm used to largely dealing with the highway projects, and in highway projects, these projects, I will relate my experience to. So there is long or linear strips around the alignment, which is to be provided to the contractor for constructing the highway. So generally, it involves acquisition of land or transfer of government land and removal of encroachments, etc. And 90% of the land is to be made available now within 30 days of the execution of the agreement. And the appendix to the agreement, you have to specify by which time you will make available the remaining pieces of land. So this is one area where there is maximum dispute, because the acquisition process does not get completed in terms of either the legal processes have not come to an end, or even if the processes have come to an end, but the distribution of the compensation has not happened, and therefore the revenue authorities face resistance because of lack of distribution of compensation. The other area is of the encroachments which are there. These encroachments need to be removed, and uh, although in paper generally the many of the contractors agree to take over the land, but they often come back and they review the fact that they took over the land, and therein the dispute starts. The other area also is of the issue of the maintenance. So the contractors are supposed to maintain the highway in the condition it was before at the time of the issue of the notice of tender. And till the time the tenders, the contract is entered into, the responsibility of the principal is to ensure that it remains in the same state as it was 10 days before the notice of the tender was published. And generally there is a dispute about that also. So these are some of the areas in which disputes do take place, and there is a lot of bad blood between the contractor and the government, particularly in the linear infrastructure projects during the period of the between the period of the execution of the agreement and the commencement of the project. So, in my opinion, if there are such issues, the contractors should insist that only he takes over only that part of land which is available to him significantly without dispute or without encroachment, and is available and accessible to him.
Sir, yeah, you already told me 90% land and other things, but can you just suggest, what could be the ways around this, sir, just to avoid these kind of, time gaps?
Uh, it, the remedy lies in the hands of the government or the principal of the uh, project, because often they start contracting even before the land is available to them, or they do really visualize that land will become available to them by the time they are in a position to make the land of appropriate length available to the contractor. In such cases, my view is that the contractor should insist and do not enter into an agreement if they are of a reasonable opinion that the significant amount of land is available. Because dispute, although at times it is thought that it is profitable to the contractor, but in terms of it really blocks his ability to swiftly and speedily execute the contract and get out of that contract and take over other works, which in my opinion, if it is not able to free him of that contract because of the issues that we just discussed, a significant amount of his or its capacity is locked up. So on the one hand, there is a responsibility of the principals to make sure that they have the requisite land available and they have made the necessary preparation before they enter into agreement. The contractor should also make sure and confirm that the principal is in a position to provide them the land as per the agreement.
Mr. Sanjay, I'll turn towards you. What are the major challenges you face while drafting or preparing claims for the client? You are on mute, Mr. Sanjay. You are on mute. Yeah, please mind. Yeah.
Can you hear? Oh, sorry.
Yes, yes, yes.
The major challenge which often come to us while preparing claims is that many a times we feel that client either have incomplete or inadequate documents because they don't prepare the records which are essential for preparing claims. Also, insofar as quantifying claims and damages is concerned, and these are mostly calculations which has to be calculated on the basis of data available with them. So when you don't have standard systematic clients, many a time the documents will found random. They are not placed together, and neither sometimes auditing is not done. So in that case, we find difficult to quantify the claim despite having the claims. So I'll give you illustration. For instance, to sometimes many of the clients are to some not to pay tax to evade tax, they will not put the amount in the books or accounts. So because that reason, we are not able to claim that amount. That is one of the issue which comes. Also, it is seen in many of the contract that despite the client having a claim, but they have not notified the claim, as I said earlier, within the period. So the issue of limitation notify the claims comes. So in big contract, in big claims, sometimes the big amount is forgone only because of the reason of limitation. That though we try to explain in the claim petition by drafting the cause of action, but that issue, issue becomes such a big issue that it will delay the entire arbitral proceedings. It will go on this limitation part aspect itself. But that is one of the hurdle which often we come while preparing these statement claims. And also, it is seen many of the cases, the clients lack clear understanding to grasp the contract obligation of the contract. But in the contract, the right obligations are defined. So client due to some, because when the execution is there, the party are there. So okay, I know the clause, I will go execute. But they don't go through the contract clause, what the clause itself says, and what are my rights and obligation of the contract, and what rights and obligation of the government or NHI. So because that region, many a time, it is interlinked. So to segregate that part is one of the cumbersome job while preparing the claims. So what I suggest that the for the client, for those clients, they should, if you want to go in arbitration, in any claims have to go for arbitration, then at the initial stage of itself, you have to engage an expert who has a domain practice in arbitration, so that at least you can get the claims wherever you have genuine claims. Otherwise, many a time, despite having genuine claims, they have to forego only because of this lack of understanding, lack of grasping the contract obligation in the contract. That is the challenge there, sir.
Thank you. Dr. Swati, how is technology shaping the way infrastructure arbitrations are conducted, from evidence management to tribunal efficiency?
See, like they say that every dark cloud has a silver lining. I believe COVID also has come with its own silver lining in the form of online, uh, meetings now. Such a beautiful webinar we are having today, all thanks to the fact that we can have them online. Otherwise, we were all constrained by time and travel. So the same, blessing can be said to have come to the arbitration system as well, because now we have the concept of ODR, which is the online dispute resolution system, wherein arbitrations have now gone online. So we are no longer constrained by boundaries, so to say. As far as evidence taking is concerned, we all know that with special reference to infrastructural projects, the evidence taking can take months. Such a huge bulk of evidence we have. So all because of the now AI and the data management that with the incoming softwares that we have, artificial intelligence, it is now evidence taking is more streamlined. It is more flexible. It is in fact more confidential, just because we don't have those big bags. If you remember, all the senior advocates and all the arbitration lawyers used to come with those huge a battery of lawyers dragging all those trolley bags with the huge case files, and which made sort of confidentiality or the more risky, because you would leave around one file somewhere and there goes your confidentiality. So now with the advent of artificial intelligence and data management, we have better confidentiality management issues also. Then we have, for example, blockchain system. We have other security measures that can ensure that confidentiality is maintained, data is managed in a more specific manner. coupled with the fact that we have the arbitrators available online and all the parties can give their evidence online, which also, in a manner deals with the delays that are caused due to the party being unavailable at that particular time or hour. Uh, Letting them come online is a short way, in a way, to ensure that they come on time. So technology has definitely helped us in a big manner as far as data analytics is concerned, as far as document review is concerned. All these things have been enabled all thanks to the technology now. However, one area where we lag is that not all advocates or not all arbitrators are equipped to deal with technology. So that poses one hiccup in the sense that we'll have hearings where, because of an arbitrator not being well versed with the process, there will be some delay or infrastructural issues. For example, there might not be a quiet room with the proper Wi-Fi connectivity. So that also causes some problems, especially in areas that are not as advanced as Delhi or the other metropolitans. So lack of infrastructural facilities causes a big problem. But otherwise, all in all, I mean, if we were to measure the pros with the cons, I would say that we have more pros than cons. And we are definitely working on the cons as well. And I'm sure the day is not far when we would have a foolproof technology system where we are not riddled with that much dreaded buffering, and the data can transfer much faster, and we nobody will have that excuse to say, oh my god, my there seems to be some problem with the network, so please give us an adjournment. So that excuse will be a thing of the past.
Wonderful, wonderful. So, besides, these, access to the technology or some, bandwidth issues and all, could there be any other concerns regarding technology, ma'am?
Well, the major concern, again, see, every coin has a flip side. So, on the one hand, when I say that data management and various security, AI security has rendered confidentiality better, in another breath, I would also go ahead and say, well, people who are very well versed with the technology, they can, well, always breach it. As far as a hard file is concerned, you can sit on it, you can put it in a safe somewhere, but the same thing cannot be done with online data. So, data breaches, on the one hand, we say that they have become safer. On the other hand, I would also go as far as saying that they have become unsafer. And then technology, in the sense, has got with it its own problems, because see, with the advent of technology, all the international arbitral agencies have also expected us to pull up our laws. But the speed with which the technology is coming to us, the same speed is not seen when we try to match up with the international arbitration institutions. So we need to pull up ourselves in a way over there. And again, as far as the infrastructural facilities are concerned, and as far as updating our arbitrators and increasing our pool of arbitrators is concerned, there is another issue over there also. So we need to work in that arena as well.
Thank you, ma'am. We have done a survey on the LinkedIn, Nagendra sir. So we did a survey that what is the biggest challenge you face in domestic arbitration in infrastructure projects, and the top two reasons were delay in concluding the arbitration. We have already discussed. The other one is the high cost of arbitration. So, sir, can you share some practical tips for managing such costs of arbitration? Sir, you are on mute, sir.
Okay. So there are dispute resolution frameworks even before we come to the stage of arbitration. And I think we need to make full use of that. If the dispute resolution mechanisms such as dispute resolution boards, or now I believe mediation has also, or conciliation has also been made a part of the three-stage process before it gets to the arbitration. So first in authority engineer, and then thereafter dispute resolution board, and thereafter conciliation. And only when these fail to resolve the disputes. In fact, in my opinion, the contractor should make full use of these opportunities, because if all these stages have ruled in the favor of the contractor, in fact, it strengthens the hand of the contractor or the client in contractor in case the matter or dispute goes to the stage of arbitration, because the other authorities have already ruled in their favor. So I think one of these is this. The other thing have already been mentioned by fellow panelists, like having your documentations done properly and presenting them. The other thing which I would kind of believe is important is to although in terms of the arbitration cost, it may not help you as much, but if you have the dispute analyzed by professionals and based on that scrutiny present claim to the arbitration, those work out. And I am saying it out of the experience that NMDC had with Tata Consulting Engineers, I guess. So there they had a dispute, and uh, there was a central government PSU which had done the delay analysis, and based on that, they had agreed to what the recommendation of the professional agency was. And Tata Consulting Engineers lost the arbitration because they raised claim much over and above what the professional agencies had uh, analyzed in terms of the cost of the delays and other disputes and the attributability to the different parties. So I believe preparing well, making use of all the avenues and preventing disputes, these are some of the ways in which we could reduce the cost of dispute resolution. Let's not say it arbitration, but dispute resolution. If it goes to the stage of arbitration, obviously it will take time to resolve those disputes, and you are not sure if it will go in your favor. And as was mentioned by Mr. Paul earlier, that even the enforcement face significant delays. So in terms of its contribution to your balance sheet, it becomes a kind of uh, issue or revenue stream which you have to write off in the immediate term.
Okay, so now I'll just quickly take two questions from the audience. When land allocation and R&R are the major problems in many infra projects, why can't government float tenders after completing these issues by themselves or through any other tender, employing some consultants, that will enhance completion of the project also. I think Nagendra sir, you would be the best person to answer this.
You are absolutely right that the spirit of the government directions are what the person the person had in mind. But often there is also this pressure of undertaking project works, and people start uh, contracting, and they are unable to meet with the deadline. The other thing is also the unpredictable nature of the revenue matters, because in such cases it is the state revenue departments at the district level and at lower levels which have to render assistance for taking over the land or removal of the encroachment. And often they are unable to discharge their duties because of lack of manpower or other preoccupations which often plague district administrations or revenue administration in all parts of the country. So I would certainly agree with the proposition that they should first make the necessary preparation and then only go in for tendering. But oftentimes, even the reasonable approximation of the time which it will take in completing those formalities goes haywire because of the uncertainties in getting over those processes. I remember in NHIDCL, where I was the managing director, and we were seeking removal of the utilities and transfer of some parcels of land. And despite my 2.5 years of effort in that organization with state government of Assam, we were only partially successful. So these issues are often at times not in the hand of the contracting agency, and we face delays. Ideally, what should happen has been mentioned in the comment.
Right, sir. So I'll take just last question and then one comment and then we'll close. Quickly, I turn to Dr. Swati. Blockchain was mentioned as a technology enabler. Can you please elaborate specifically how blockchain is enabling arbitration?
See, arbitration is enabled by blockchain because blockchain facilitates multiple user to upload certain information. At the same time, it ensures that information does not get leaked. So arbitration is one area where multiple people are using the same, maybe data management. They're having to upload documents. They're sharing the documents. So in order to ensure that despite multiple users, the confidentiality does not get compromised, blockchain can be a very good use of technology in this instance.
Thank you. One last question. No, it's not a question from Dr. Dipankar Adhya. He says, thank you for organizing this webinar, very relevant in today's situation where certain factors are not even in full control of government. Sir, it will be great. It will be of great reference and help if we can have the recording of this webinar. So Dr. Dipankar, yes, the recording is available on our YouTube channel. And I'll ask my IT team to share the link with all the participants. And with this, I conclude today's webinar. And I thank you. I thank so much to our speakers, Nagendra sir, Dr. Swati, and Mr. Sanjay Chetri. And thank you, the IT support team, for organizing this webinar. And above all the participants who have come here to join us, so that we are encouraged to do more such webinars. With this, I conclude. Thank you so
Thank you.
much.
Thank you, sir.
Namaskar.
Thank
Jai
you, sir.
Hind.
Jai Hind.